The simple answer to the question of when can I modify my child custody arrangement is when there's been a change in circumstance and it's no longer working. There are many things that a court looks into to determine whether you can change a custody judgment. The biggest one is there a substantial change in circumstance in order to do so that would warrant a change in the judgment? Just because you no longer like the arrangement is not often a good enough reason for a judge to modify your custody judgment. A judge is not likely to modify your parenting schedule because you've decided, I like to have the child on Saturdays instead of Sundays, or I have decided I just want Wednesday and Thursday instead of Tuesday and Wednesday. That would be a situation where you likely don't have enough to change a custody judgment. Now, if you were in a situation where your work schedule changed and now you work every single day that the child is supposed to be with you and not on the days the child is with the other parent, that could be a substantial change in circumstance to warrant a custody change. If your co-parent who has the child, 50% of the time is now working out of state and is only taking the child one day a week, that would be enough or could be enough for you to come in and say, well, now I need primary custody. Child needs to be with me the majority of the time because that's what's happening already and the other parent cannot take their parenting time. How do you request a custody modification? There are a number of ways you can request a custody modification. If you and your co-parent agree to modify, to change the schedule, you can file a joint petition for modification where you're going in together, filling out paperwork, supplying the court with what your new order is, and saying this is what we want to do. If that's not the case and you're not agreeing to modify your schedule, you would file a complaint for modification in the courts and the process would start. Just like within a divorce or an initial custody petition, you'll get a summons. You have to have the other parent served with the summons to let them know the case is proceeding or the case has started, and then your case would proceed from there. How does the best interest of your child play a role within a modification? At the center of every court case that children are involved in, the court is looking at the best interest of your child. So just because you're modifying your court order and it's not your initial divorce or your initial custody proceedings, the court is still focused on the best interest of your child. If your ex is moving an hour away or 2 hours away and trying to keep a shared custody schedule, the court would likely come in and look and say, well, it's probably not in the best interest of your child to spend 2 hours driving to school every day and 2 hours driving home. So the central focus of the court at all times is what is on the best interest of your child. The main reasons I see parents coming in looking to modify their custody arrangements are probably one parent moving a long distance away from the other parent. Generally, we'll see parents come to custody arrangements, shared custody arrangements when they're living close together and one parent has now decided to move an hour and a half away, and that's no longer working for both parents and the child. The other main reason people come in for a custody modification will be because of schedule changes. They may travel for work a lot more. Their hours may have adjusted so they're not able to be with the child as much as they were before or on the same days. And finally, because the parties just can't agree. They can't agree on what is best for the child or what schedule may be best, and they need the court's help at determining that. We do custody modification cases all the time here at O'Connor Family Law. If you're looking to have your custody schedule, custody situation changed, modified, give us a call.